Hello, everyone. Welcome to the next episode of the Shmoozin with Forouzan podcast. Excited here. I'm with Mr. Jason Ingber. Jason's an attorney just like myself. He has tried at least 4 cases this year that I know of, maybe more. He has his own podcast. I've been on his podcast. Lots to chat about. As you guys probably know, I am very interested in the mindset of litigators and trial attorneys. It is a tough job to be a litigator. It's an even tougher job to be a trial attorney. And there's a lots of ups and downs that come with that. And I'm always so curious how people feel, how people cope, how people push through. And that's why we have Jason here today. He's got quite a bit of trial experience from just this year to chat about. Jason, nice to have you on the podcast.
So excited, Daniel. Really pumped. Thanks for having me on.
Yeah, it's a pleasure to have you on. I think anyone who tries 4 cases in a year, regardless of what area of the law or whatever, any trial is an undertaking. As I understand it, you had 2 bench trials and 2 jury trials this year, right?
Yes.
Okay. Let's focus on the jury trials. The jury trials, how long were?
Both jury trials that I did were over 2 weeks. Yeah. One of them, the voir dire process was 3 days, which I know from the first trial, voir dire was, I think, 4 hours in total. Which I heard is more typical. It's usually a lot faster than it's depicted in the movies. And the second trial was a 3-day process. So I was really fortunate to do these trials back to back. It's kind of like I went to the Comedy Store when I was much younger. I wanted to be a comedian, and I used to go like night in and night out to watch the performers do the same routine with the same gusto and see how they tweaked it from the night before, like Joe Rogan, all the other named people there. Just watch them like mess up, watch them do it again. So I got to do that. I was second chair in both trials, but it was back to back. So it was really fresh with like the experience of each judge, with each first counsel, the defense counsel, the juries, the reactions, and both were completely unique experiences, really different. And so I learned a lot.
It's such the whole litigation trial game is so heavily focused on, I don't want to say experience because that's obvious, but it's what comes with experience. I mean, I'm now in my 10th or 11th year of practice, and I can get on the phone with opposing counsel without even knowing what the phone call is going to be about. Earlier in my career, I'd have to know, I'd write notes, I'd have a scheme and strategy for how just the phone call was going to go. So that's an example of experience. So here you're telling me you try 2 cases back to back. I can only imagine how that experience compounded. When you say back to back, how much time between the 2 trials?
Literally 1 week.
Wow.
So I had enough time to like do my dry cleaning to get my suits back in order.
Yeah. Yeah, that's intense. And that the week, so you didn't feel burnt out after trial number 1 before you went into trial number 2?
I was gasping for air. Totally totally burnt out. But how do you pass up the opportunity? Especially the second trial that I did, I knew was going to be a victor, like a victorious one. So if it would have been the other order, I wouldn't have done it. I lost the first trial, and I knew that we were going to lose going in. So if the experiences would have been the other way, I probably would have dropped out. I would have been so burnt out. So that's a good point. The burnout is real. I mean, it's grueling. Like we're pretty extroverted, me and you, and folks that gravitate to litigation and stick with it and end up in trial work and interested in that kind of work. There's generally an inclination to extroversion, and the amount of time you have to just sit there at a table and you're being watched by the judge, the jury, the other side, the whole time you have to be on your best behavior. And like driving to the courthouse and driving out of the courthouse. It's like, 7:30 a.m. to like 6 p.m. You're just like a soldier in a suit. It's grueling, just that in and of itself, besides for the mental engagement you need to perform at.
Yeah, the last trial I tried was in Riverside, and we all ate at the same place. There was like 2 restaurants. And so our jurors were always in the restaurants, and it was always awkward. We'd always have to get places to sit far away from them and kind of be hush hush and make sure they couldn't hear us. So I certainly appreciate that you have to be on. So credit to you for doing them. And something interesting you pointed out, you said, well, I knew I was going to lose the first one. There are some non-lawyers who listen to my podcast, so they might not understand why someone would try a case when they think they're going to lose it. You want to kind of go into some of that and explain your thoughts and process with the first trial?
Yeah, totally. I definitely can understand that's perplexing, but ultimately we're agents of the client. And I'm not saying that to hide behind anything. This guy wanted to go to trial. He needed to hear it from a jury, a judge. And even afterwards, he was like trying to appeal things. Like he's just dead set on his perspective of the situation. So if you're being paid on an hourly basis, the risk is mostly on the client if you're being very explicit with the odds of pulling out in victory. So this person really wanted us to go to trial and, like you said, trying it anyway. So then why should I do it? Even if he's going to pay me. So why is that good enough? But it was going to be my first trial. It was substantive. Our side was claiming over $1 million in loss. It was a real estate dispute. And so I wanted to dig in. It was a sophisticated way of getting my practice in.
That's interesting. Let me ask you, was there, I'm going to say, was there a vibe difference between trying a real estate case and then moving on to your second trial, which, as I understand it, was a personal injury case?
Yeah, totally. One of my mentors said, if you give me good injuries, I'll give you liability. And that is a good statement. The first case was about a guy that owned a parcel of land, and he hired a real estate developer who had all these big schemes that he was going to do for him. He's going to develop it into 3 little lots and a mini HOA situation. And then the plans went up in smoke. They couldn't get the permits they needed. And the damages in something like that it's murky. You have to tell a story. You have to be like, oh, he would have flipped the property commercially viably for this amount. If in the other case, someone died, you don't really need, like, the gravity of the situation's immediately present. It's arresting. You could say it in one line, someone died here and it's someone else's fault. I could give you the snapshot of that case too.
Sure.
Yeah. So there was a guy that was on a wheelchair. He had moved here from Korea to earn money for his family. He had previously actually moved to Saudi Arabia to work for Hyundai, developing these windmills. And they could only work from like 2 a.m. to like 8 a.m. because the rest of the day was like so hot. So this is the type of guy he was. He was always like a bit of an adventurer, but sending money back to his kids. So he moves to LA and he had filed paperwork for his children to get here legally. One of them came to live with him, not yet legally, and he had a stroke. So then another one finally legally got to get here, and this is all important. So he ends up one day in a wheelchair. He couldn't walk very well. He ends up in a wheelchair, and he's going down this really busy boulevard. And there was an auto body shop that when they would be finished servicing their cars, they would park them on the sidewalk, like encroached on their land and on the sidewalk. It was just easier to get the cars in and out. And on this particular day, they had those cars. He approached that part of the sidewalk, had to go around, and their slope of their driveway was too steep according to regulations by the ADA, by the county, the state, the city, everybody. And so the steepness caused his wheelchair to get him to go really fast into the street. And he got hit by a truck, but he didn't even die on impact of the front wheels of the truck. He went under the truck and got crushed by the back wheels of the truck. Yeah. So this is a really bad accident. I mean, he died. And we sued the body shop. The owners of the body shop were actually also Korean. They didn't respond to the lawsuit at all. The operators of the body shop did respond to the lawsuit, and that's who we went to trial against and prevailed to the tune of $896,000, which was discounted for some contributory negligence that the jury deemed was our client's fault, to $547,000.
Okay. So you basically got $1 million. They gave you some comparative fault, got, a little less than that, but still, interesting case, horrible case. When you say the city said that the sidewalk wasn't up to code, did you have some kind of report or record from the city, or is it just based on the ordinances and your measurements?
Precisely the latter. Ordinances, measurements. It's a non-conforming use, so it's not like you have to tear down slopes of that nature, but if you build new property, it can't have been that steep. So it was problematic, and they knew it.
And in case anyone wonders, what is it that a lawyer does? You see all this stuff on TV. Majority of what you're doing as a lawyer is going and say, what does the code say, and what were the facts, and how does the code and the facts come together? Most of that's done behind a computer, by the way. It's not, is it Harvey Spence or whatever from Suits? He's always walking around threatening people and things. It's not like that. It's mostly just behind a computer. And this is a deep dive into an example of how it's actually done. So that's interesting. So this poor soul is on his wheelchair. He is going down the sidewalk. The sidewalk was not constructed correctly, and there was at least a construction recent enough that it should have been up to code. As a result of how the vehicle was parked, he ends up sliding into the street. He couldn't help himself, granted the slope of the sidewalk, and a truck just comes over and takes him out.
Absolutely. I also will commend you for your Jim Halpertness. You don't know who Harvey Specter is, so I don't know if you know who Jim Halpert is from The Office. You don't. Man, I love you. You're a god to me. The fact that these like tremendous pop culture references. Next, I'm going to be like LeBron James. You'd be like, who? But you like looked at the camera when you're addressing the audience. You look at me when you're talking. Like you're very cognizant of like how you're running this production. That's cool. I like that.
It's some trial and error. It was my uncle who pointed out to me that I'm never staring at the right place. So I eventually figured it out.
It's funny. Shout out to Uncle Forouzan.
Yeah, thank you, Sully. But okay, so you tried these two cases effectively back to back, 1 week in between the two of them. I like to ask questions that are helpful, especially to newer lawyers, especially to people who have less litigation or trial experience. When you went into the first case, knowing it might be a dud, what was the mindset and what were the ebbs and flows of your thoughts? Some of them positive, some of them negative. Give us all the gory details.
Yeah, that's a good question. It was really rough mentally, but I had to compartmentalize and I said, let's just put on the best show possible. And I think we really did do a good job. The problem was when it was our client's turn to take the stand. So this is an attorney. He is an attorney. He's like a transactional wills and trusts attorney. So not a litigation attorney, but nonetheless an attorney. And he had signed paperwork, which had this disclaimer that you can't sue the developer like under any circumstances. So that was like a huge barrier to the case, right? So aside from that monumental problem, he's standing on the stand and the defense counsel, the other side, is grilling him. Who really owns this property? And after a few questions, he comes up with his answer is, I don't know, right? Because there was some like not shadiness, but it was like his mother in a trust from the friend. I don't even know, right? But you can't say, I don't know. We tried the case in Burbank. It was like all retired actors. Like you got to give them something more tangible, some better story than just, I don't know. You're going to come off as no credibility. So that was like halfway through the trial. And that point I knew, okay, we lost. Like, so really to fully answer your question, from the beginning to that point, I was really gung-ho. Like I had done a couple witnesses. I was like very much trying to just put on the best show possible. And then from that point on, it was more just like, don't look defeated, just try and get through this and make sure no one realizes how bad this is going.
That's heavy, but understandable and commendable that you went through with it. Did you feel when he said what he said, did you feel the air just like slip out the courtroom?
Totally. And I was studying out of the corner of my eye. Like I could see half of the jury for the most part of the trial. Like I was able to like see their reactions, and you kind of just see them like they just lost it from there. Like some of them were actively like cringing at the guy, and I'm just like, oh God. Yeah.
Yeah, I had something like that in a case that I tried. Is also happened to be a business case about ownership of a company. And during the deposition, which was videotaped, the defendant was asked, well, if the plaintiff owned, this much of the question was, why did you sell this company and keep all the money if the plaintiff owned a third of the company? And so the lawyer who was taking that particular deposition said, well, you sold the company. And he goes, yeah. So, well, didn't the plaintiff own 33%? And the defendant goes, so what? And, we got that on tape. We showed the video to the jury, and it was, thankfully, in my case, it was the reverse. They gasped at the defendant. And at that point, I was like, maybe we have a shot here. So it's interesting, the jury does kind of let you know what they're thinking sometimes, right?
Totally. And in the second trial, they asked questions in the form of written like responses. They had took their notebooks and were writing out all these questions. These questions were so high level, Daniel. I'm telling you, like attorney level questions. They're asking about like causation and how does it impact, like things that you were touching on when you were asking me the question. They are asking that, but like, and I had thought, oh man, we for sure lost them because it gets so boring. The ADA regulations, it's like you were saying, getting evidence in is a challenge. We had talked about this once. It is, and you have to do these like really annoying, drawn out ways to lay foundation. But the jury was so locked in, and it gave me a lot of hope. It gave me a lot of hope in judges and juries. These experiences were very inspiring to me.
What do you mean when you say it gave you a lot of hope? Like hope that, something, again, to my non-lawyer friends, I apologize in advance for this one, but sometimes there's a sense that if things get too technical, the jury might not get it. Was that your concern?
That was definitely a concern, but the fact that they both, like this random pool of people got it so right, in my opinion, was very inspiring to me. And both judges too, to bite their tongue at what they thought was the right, like the judge in the case where we lost in chambers, only once did he reveal, he's like, you guys are being preposterous, like there's no case here. But to the jury, he didn't reveal that once. He was so fair. And I had studied that. I'm like, could it, I'm like, is it possible that you could tell his bias? No. He's shutting both sides down. He's not, knock it off, counsel. Like you really couldn't tell. And I thought Judge Kralik, an Irishman, fascinating guy. He had, I was trying to kiss his ass. So I looked him up like crazy, to see what I could bring up in the middle of the case or whatever. He had written a book. He ran his own firm. It went to bankruptcy. He got divorced twice. He was living alone in his apartment in the cold and in the heat with like no air conditioning in Burbank. And he realized he needed to make a change. And he started thinking about how he could be grateful. And he started with writing a thank you letter a day to someone. It could have been a barista, a partner he had used to work with. And through gratitude, he like found himself again. And then he ended up on the bench. And he was really just a model citizen, a very, very good person, very interesting guy. And the other judge too, just exceptional people. So I really had a lot of respect for them. Yeah.
So I have to ask, judge says to you, Mr. Ingber, this is preposterous. What is the first thing that goes through your heads when you hear that?
Fuck yeah, dude. I know it is. I know it is, Your Honor. I feel like just as bad as you that we're still doing this. That's the thing also. It's like the amount, it's a reason why I'm 97%. And I think that's the true number. 97% of cases settle because it's just such a production. Like they have to send out like 80 jury summons to get the 40 people to pool them. And then you go through the evidence for days and days and opening arguments, closing arguments. It's just like, it's an unbelievable amount of resources and time and effort. And knowing that I was doing that, hearing him say what I was thinking was really comforting, to be honest. I'm not going to lie. I was so done. I was so done with that case. Yeah, really unfortunate. It was also interesting to see, like, you think sometimes that, oh, someone brings a case and they'll for sure win. They'll get something. The jury said no. The jury gave us $0. The other side came out completely victorious and unscathed from all this hell, from all this litigation. They didn't back down once. And I think that that's kind of cool too, to know that about our adversarial system. Like sometimes it's an interesting but rightful system.
Yeah, the adversarialness of it is interesting to me in the sense that the adversarial nature of it instigates the zealous advocacy. It kind of forces you to be sharper and sharper. And then on the other hand, sometimes there might be reasonable middle ground, which may get lost due to the adversarial nature. So I always think that's a kind of an interesting thing. Mentally going into the second trial. So we talked about the first trial. The second trial, what was your mindset when you were starting it?
I'd done a lot of prep work. At nights, I was talking to these clients going into this case. And then for that week before and the month before that, I had done some work for the case. So we were really prepared. Going into that trial, I was super confident. Like I said, I knew we were going to be victorious. It was just a matter of how much. So it was a really awesome feeling. it was also awesome to be on like a rightful side. Like this was the side that I really believed was right. I wasn't, there's no element of just trying to shake someone down. Like they were clearly, it's a 1 in a million thing to happen. Someone like happens to be someone on their wheelchair engages with this car. But the bottom line is I thought of the problem as they had been doing this for 20 years since they were operating this body shop. So for 20 years, they borrowed the public right of way every single day, not paying for it, not paying taxes for it. And then this is the tax. Like someone died. To put it in clinical capitalistic terms, like you have to pay for that. That was bound to happen one time out of 20 years, and it did. So we really pressed him on it.
How was the jury pool in the second trial?
It was Inglewood. It was interesting. It felt like even a bigger cross sectionality than Burbank, and I was really instrumental. Like I said, it was a 3-day voir dire, and I like to think that I helped pick a good jury that picked us that gave us the verdict. I actually also bought pens and clipboards. The courtroom didn't have them, so I donated. If you ever try a case before Judge Ronald F. Frank in Inglewood, the clipboards that your jury will use are donated courtesy of Jason Ingber, and the pens. And I thought that was really so not fair, like unfair play, because like it causes some level of influence, right? Like I'm bribing the courtroom. Like the assistant is like chummy with me now. Like I bought you the pens, motherfucker. Like you don't you forget it,
Wait, why does a courtroom not have pens?
I don't know. That's what I was saying. I was
mean,
like,
no one uses pens in a courtroom, right?
Right. Exactly. So, but that is what happened, and they were a great jury. The reason it took 3 days is because this judge allowed us to give them a question and answer sheet. So we went through the question and answers at night, and then both sides had knocked out so many people that they needed to bring in more jurors to do it again for another day. But really studying the questions and seeing how people are really thoughtful. Also another thing about jury duty is that people that end up in that box, they want to be there and they're doing a service. Mm-hmm. And it gets colloquially made fun of so much in pop culture, but there was one woman that had a tortoise convention, okay, in Long Beach. This was in the first trial. And so the entire trial, we didn't do Fridays because of this woman, because she had back-to-back tortoise convention weekends. Like the fact that we were making it work for this tortoise convention person to be the one sitting, like everyone's kind of working together. There's that real kumbaya feeling about it. That was really nice.
Do you know if any of the jurors stayed in touch after the jury trials?
I gave my contact information on the second trial to a few of them and talked to a few of them, which was also a very interesting experience. A few of them wanted to just go home. I don't blame them. It was like 2.5 weeks. They're like, oh, holy cow, are you freaking kidding me? You want more of my time, But a few of them were very interested. It was fascinating to hear from one of the jurors, really, that gave me most of his time after, how they were negotiating, how some jurors were like, no, it should only be 100 grand of a victory. And some jurors were like, it should be 2 million. And they literally were negotiating with each other to the number that they ended up arriving at, which was really cool. I didn't think about the process of what that's like in that juror room at the end of it there. But they deliberated for over a day. And the first jury was done after 45 minutes. They were like, yeah, we're done here. Like, I don't know, it's not even enough time to sit down and have a cup of coffee. But the second jury was over like something like 2 days deliberations.
Interesting. Yeah, I remember in one case the jury came to us out. Some of the jurors came to us after. This is the same one I told you about earlier, actually. And once they said that scene we saw in the video when he goes, so what? And they gave us 5.2. It wasn't contingency, unfortunately. It was hourly. But they're like, we thought 5. 2 of them were like, we wanted to give you 10, 11, 12 when we saw the video. And so on one hand, you get your hopes really high because you speak to some jurors who give you these higher numbers. You're like, whoa, I was so close to getting even double what we got. I'm sure there's other jurors who are like, well, no, we were looking to give you less. So you kind of get a spread, don't you, once you speak with the jurors afterwards?
Yeah. Do you feel like it's a weird thing? Like me and you were in this line of work where our advertisement sometimes has to be like, oh, I made $5.2 million, like a picture of you with your arms crossed in a suit and your logo.
Mhm.
And then you're posting on your kind of personal social media handles in a way. You're posting 5.2 million. Now everybody's like, well, this guy's paying for dinner the next time I go out with him. Like, is that weird? Is that a weird part, do you think? Like
Yes.
you were able to make the distinction to me, like, oh, it's not contingency, but like how you gonna write that in a post? I mean, maybe you could, but either way, it's a weird element.
Horribly weird, especially I'm what was the last, one of the last things I posted in a suit with my logo, and the number was $1 million we did on a personal injury case, upper extremity injury. And it is a little strange. It's like, Daniel Forouzan, $1 million, because my client's arm was broken pretty badly. So it's it's a celebratory time. Don't get me wrong, my client's very happy. Him and I have beers scheduled. So he's very gracious about the whole thing, and he's happy about the money that he's about to get as a result of the $1 million settlement. But it's strange because, they say the lawyers do the work, which they do, but the client suffers the injury. And I think the client's the one who does the real work. And then I go on a poster with my arms crossed in a suit with this logo, with a number. It's a peculiar job. You're right. It's a peculiar job.
It is a peculiar job, but I like the first case that we lost. How did I know it was a loser? Because when the guy couldn't tell me how he was wronged in like under a minute,
yeah,
there you go. So sometimes though people come in and they're wronged and they tell you about it, and it's a glaring problem. Like you're like, okay, this is a valid problem, but how are you going to get to the money? Like you said, so much about lawyering is investigating. Like, where is insurance coverage? We need to sue some corporation that actually has pockets here, and getting creative with how you come up with liability and different theories. Like, I think ultimately lawyers get paid what they get paid. Like, I think it's a fair system. I mean, obviously I'm tremendously biased as a lawyer, but
yeah, I'm with you. I think lawyers should get paid what they paid and possibly more. Not that I have any bias. No, I'm kidding. Lawyers do get paid handsomely for the work, but understandably so. It's not the easiest job, laborious and adversarial. So I understand that. With regards to the areas of law, so you had what sounds like a civil litigation case, then a personal injury case, so real estate, wrongful death. Did you prefer one over the other? Did you have a sense of, oh, I want more cases like this, or I want more cases like that, and why?
I love that. Yeah. I want more cases that make more money. Okay. That's the only criteria that really matters. And I'm not being facetious about that. And that has to do with having a real issue, a real problem that needs to be solved through our adversarial court system. So I really don't care what the type of case is, as long as it's something that's juicy, something that's real, something that I believe in, because you live and breathe with these facts for like years potentially, and you have to keep regurgitating it through paperwork, conversations, and whatnot, in different iterations, different mediums. So anytime I have the ability to work on a case that I really believe in, I'm all for it. I'm really all for it.
Yeah.
Yeah.
If I is so your practice, it sounds like you do some civil and some PI. I know PI is civil, but what I mean is business litigation and personal injury. What is can you give me just a general idea of the breakdown of your practice areas?
Kind of. I had worked on Scottie Pippen's divorce when he's divorcing Larsa Pippen. I did that for a year and a half. I was staffed on it tangentially, but I was on conference calls with Scottie, and I said to myself, okay, this is the only law I won't ever do if I go on my own. And actually, that was the time period where I met you, and you had inspired me to go on my own. Because yeah, totally. We had a cigar at Sam Yebry's, like one of his fundraisers. He was trying to run for council. I think he'll keep trying to run. He'll win eventually. And I met you there that night. And you were telling me about how you opened up your own shop and how you love the fact that you have autonomy to run the cases the way you want to. And I was like, man, I got to figure out how to be that guy. And at the time, I was slogging through these like completely bullshit filings and ex parte, like emergency filings that the clearly the lawyers were just cooking up on both sides. And they'll both deny it, and they have plausible deniability at it too, because it's hard to pinpoint when there's nefarious activity. But I'll fight if I need to fight, but you gotta, there's too much emotional charge in those kinds of things. So the most long-winded answer to your question possible, it seems, we've arrived at the answer, which is that I'll do pretty much anything. I worked in big law for a few years out of UCLA Law. I worked at Reed Smith and Squire Patton Boggs. These are international firms with like 1,500 lawyers in 47 countries. And I did mostly defense of banks and telemarketing companies for consumer statutes. So wrongful debt collection of mortgages, of credit cards, or too much telemarketing through phones in class action context. So I really got good experience. I cut my teeth learning how to do fights when I was Darth Vader. I was the big guy with the biggest army, and I could do whatever the hell I wanted, and no one questioned me. And it was really awesome, and I learned a ton. Now on the other side, I'll do pretty much anything except for family law. I'm not going to be able to litigate certain things that require specific expertise, like patent bioengineering disputes. I can't do that. There's just no way. But any type of fight that someone has, you can run it through the court system. Like, you're doing business disputes of people fighting over companies. You're doing things where people's arms or legs are getting crushed. Those are completely different planets. But you can testify just as well as me that the vehicle of the court system, the vernacular, what you need to do, it's all pretty much the same, and it's common sense at the end of the day. So
Let me ask you this, and I'm going to ask you the second trial, but for the first trial, what is it that you found out, knew, or learned after the first trial that you wish you knew before?
That this is something I was born to do. And then I'm much less intimidated in how I write my motions, how I talk to opposing counsel, because I've seen how the sausage gets made now at the end of the day. What are you going to do? You're going to take me to trial. I know what that looks like. I know that this thing is not evidence that you're going to be able to present. I know what my story is going to sound like to a jury. I've done it. I've seen their faces. So I just became, if it's even possible, I became more cocky.
Okay.
But something that, something I wish I knew. Yeah, preparation is key. Preparation is everything.
So. Yeah. Okay. What about the second trial?
Second trial is that there's room for like, there are people that are way better. Like the first trial, the guy I did it with, he's an amazing person. I still do work with him. Second trial, this guy was just Michael Jordan. Like, he was so much better than I've watched trials before. Now I've done them. Like, he was just head and shoulders above, above my ability to be off the cuff, to have a handle on the evidence, to not be intimidated when like a police officer is testifying. This guy killed a police officer. He made a police metaphorically, he made a police officer look so foolish. You said people gasped. Like, he got some audible reactions from the jury, just beating this guy up. Like, what makes you a traffic expert? Like, you're not biased. You're going to tell me you're not biased to the report that you wrote. That's hearsay. What other vehicle code violations are you aware of? Because this police officer was not on our side. And the other side, he had wrote the traffic report. Is fascinating. He wrote a traffic report putting our guy, the wheelchair guy, at fault for the accident. Saying that he didn't use a crosswalk to cross this. And to this day, I don't understand why that guy had it out for like our dead Korean client. Like, I don't know why he was Korean in my explanation of my incredulity, but I don't understand why it wasn't a race thing. I just don't understand why this cop, who was like so proud to testify and back up what he said, it just made no sense to me. It had happened years before. I don't know what he was trying to do, what his ego, I couldn't figure out the motivations. But in any event, our argument was this guy shouldn't be allowed to testify because he'll be confusing to the jury. He's not a traffic expert by trade. What makes him qualified? As you know, police reports are not allowed in court. It's hearsay. So what real evidence does he have? This vague memory of something after the fact when he got to the scene? Like, what does he have to say that's useful? And so we had a mini hearing where the guy said what he was going to say to the jury. And then the judge deemed it, nope, it's not confusing. It's not prejudicial. He gets to testify. And the judge even said, I wouldn't recommend it. And the judge was like, because our guy beat him up so badly. Sure enough, he gets in front of the jury, and our guy just torches him. And he did it in a fashion that I was like, no matter how prepared I could have been, it's from experience. It's from the scar tissue of looking different cops in the eye. This guy used to be a DA. And so he had that, animal, like, I'm going to go after this guy no matter what. And I don't have that yet. So it was cool. It was cool to see that.
Was a jury laughing?
There, yeah, yeah. I mean, it wasn't like an audible gasp like yours. It wasn't like that level, but I'm watching the jury and you can see they're like, this is like HBO. Like they're getting popcorn out. Like, they're just like, dude, you're making this guy look silly. Um, there is a certain thing about an officer coming in uniform. Like he's coming strapped with a huge gun, the badge. Like this guy, and he was a black guy, and a lot of the jury was black. Like this guy's like a protector. He's a savior. He has so much inherent credibility. I really was scared. I was like, is this going to go well? Is he going to kill the case? But he didn't. The reason we didn't win the full million or even more in a wrongful death case, I think, is because our clients were Korean and they didn't speak English very well. So it was really hard to convey emotions in that story without tears, without them getting really worked up, like an American would be able to connect with the jury on that level. I really think that was a huge part of why we didn't win a lot of money.
Yeah, that's understandable. First off, you did win, in my opinion, a lot of money, but that
totally,
is,
the clients were happy. Yeah.
yeah, but that is also understandable. The ability. I mean, look, they say a picture's worth 1,000 words. Imagine what standing in front of people and testifying is worth, right? And that's the whole idea behind testimony. You want to see the facial expressions. Do they blink when they talk? Do they seem honest and dishonest? So, if there's a language barrier, I am certainly sympathetic. Was that ever something that was brought up to the jury by the judge, or say, hey, their English is not strong. Please try your best to work around that, or was that just you just went for it?
Yeah, no, it was, and we had to switch interpreters mid-trial because the first interpreter was just not an empathetic person. Like you need someone that's going to be theatrical to the extent the law allows. You're really only supposed to allow to have someone that like barely amplifies. Like there are rules about it. You can't have like Robin Williams, may he rest in peace, be like your interpreter, because he's just going to go off and do crazy things. Like it has to be a certain way, but we had to switch definitely, and it was a big improvement for the testimony to really land. I actually also read into the record, one of the kids were stuck in Korea. So they had done his deposition before the trial, like months before. And then I read his deposition in the record and I played the son at trial, which was a really interesting experience to like, I read it with like an evocative tone of like, I had to get into character of like, okay, my father died, in a wheelchair accident. It is these people's fault. But but I'm in a courtroom and I have decorum. And so I'm just like reading this guy's testimony like that. It was really interesting.
And of course, a judge is going to want you to do as little advocacy as possible. They just want a straightforward reading. But any attorney worth their salt is going to throw some advocacy in that, right?
100p. Oh, yeah.
And advocacy can come subtle. It could be overt. There's all sorts of different ways. Just facial expressions as you're saying things, pauses before certain words, pauses after certain words, of course. The interesting thing you brought up, you said the interpreter was, I don't know exact word you used, but my recollection, you said they weren't warm or they weren't empathetic. Was that what you said?
Yeah.
That is a nightmare. If I am in a jury trial and my interpreter is lackluster, we actually had that problem one time. The interpreter wasn't interpreting everything. There's a guy, he spoke Spanish, and my co-counsel also spoke Spanish. My co-counsel was like, the interpreter is not saying everything the witness is saying. So we had to do a quick sidebar with the judge. But and guys, if you wonder why lawyers have stress or why they get paid, these are the reasons. You get up there, you think you got everything together after 3 weeks of sleepless preparation, and now all of a sudden, what gets you? Oh, the interpreter talks like he's just woke up 5 minutes ago. Oh, great. So these are the anxiety-inducing things.
They also surprised us with an expert witness that wasn't on their list that the judge let them bring on. They said
it's impeach or just to present
rebuttal expert. I don't remember exactly why they were allowed to. I guess because they deemed him a rebuttal expert, but he wasn't. He was definitely telling news stories. He wasn't just rebutting. And we had no preparation for this guy. I mean, we still killed that dude. I actually took him on. He was there for 2 days, so I took him on, and we killed that dude. But it was, you talk about the stress, like that was stressful. A new expert.
What kind of expert?
it was a liability expert to talk about how the slope, and he brought in this fact, but it was kind of conjecture. But he brought in this piece of evidence that all wheelchairs that were manufactured like after 2004 or some really long ago date. So in all likelihood, this wheelchair also has anything that has a motor, which this one did, has a regenerative braking. So if you're not pushing go, it brakes. So he kind of insinuated that this guy tried to like kill himself because he had to have been pushing go the whole time. So he got to like play up that theme of the story, which I think dented our case. But it's funny when you hear sometimes lawyers go, oh, there are issues with the case. It's not always like, oh, that the client's lying. There's so many different factors and plays, and every nuance, every story has its own nuts and bolts to it. So,
have you ever done a focus group?
Yeah.
What did you think of that?
I think it was a bit of a waste of money. I think that you can get it done if you go to Starbucks and you just, and I do that. And you just like pitch cases like to the barista okay. So this is a perfect example. So the focus group will cost, when we did it with a guy named Harry. I forget his last name. Nice guy. Really, really good at what he does. Really thorough. We ran it twice. We ran the case twice. It was a girl that went to the Nightingale Plaza. It's a club on La Cienega, and she's a model. She had been on Jimmy Fallon a couple times. Like she had hit some modicum of success, and then she was roughed up by one of the bouncers. She claimed they even groped her, and they're saying nothing, and they gave no evidence in discovery. So that was the whole case, right? And we hired this focus group to run the case twice. And both times they come back like, you guys are going to lose this case, and here's why. And okay. But what I took from that is going to Starbucks. And then what I took from going to Starbucks is going to my family members. And a case that I filed today is against Toyota. Toyota came out with this hydrogen fuel cell car, not electric, not gas, hydrogen. And they had lied to people about how much per gallon you can get, in the sense that they said 400 miles to the tank. It really only gets like 250. And they also had gift cards that they gave that for $15,000, which they proposed would be for 3 years worth. So it's either your whole lease, or for 3 years into your purchase, you won't have to pay for hydrogen. But then hydrogen prices skyrocketed, so it swallowed up the value of the cards. Now, I was able to do that little spiel for you in like 45 seconds, not only because I prepared to be on your podcast, but because I talked to my nephew about this case, and I told him this whole long drawn out story of the dealerships and these people struggling at the hydrogen fuel pumps. And he's like, that's not a case. This kid's 11, right? Or 12. He's like, that's not a case. That's not a case. Until I got to the specifics of what they lied about. Okay, they lied about the fuel tank. They lied about the gift cards. He's like, there's your case. That's something specific. And like, my friend is, to this day, he manages Bruno Mars. He's like a Jewish kid that grew up with him. And Bruno I know him. I'm not really that close friends with him. If he were to ever listen to this podcast, I'd be like, bro, I didn't know we're friends. Like, we're acquaintances at best. But his sister is who I'm really close with her. And Bruno used to hang out with her when they were younger. And he used to test his melodies on her. He's like, if I can get her eyes to light up, if I can get her to buy into this thing, it's catchy, it's going to be a hit. So that's my preparation now. If I can get my mom or someone that's not a lawyer to like believe in my case or tell me where that's the focus group that matters, and you can do that. Yeah, you can do that at any time.
That's interesting. What you said just now reminds me, and we've been going about an hour. I appreciate your time. Let me bring it back to one of the first things you said. You mentioned that you had a client who couldn't really give you the case in so many minutes. And here you're telling me you were able to put that elevator speech together in a very succinct explanation of the case, which I understood and sympathized with. But it was after having a conversation with your 11-year-old relative. Yeah, so it's an interesting thing, and you hit the nail on the head when you said that earlier, that if the client can't explain the case, if you ever, for the non-lawyers amongst us who are listening, if you ever speak to a lawyer and they're asking you what your case is about, you got to be straightforward, because we fish for, are they vague? Are they really not putting together what the reasoning is behind why they were harmed and why they deserve their day in court? So I find it interesting that we started a podcast talking about that. Now you're telling me how you're focus grouping your 11-year-old relatives, and it got you where you needed to be.
Yeah, totally. I think that you're very right with your assessment. Yeah. I'm very grateful. This is a lot of fun. It was fun. It's fun having you on my podcast. Always fun talking to you. I think that's a cool part of this job. You get to meet people, get to learn about different folks, different strokes, different people's background perspectives. Yeah, really, really, really great opportunity. This is.
Yeah, the only embarrassing part is the difference in the quality of your podcast versus mine. So I was on Jason's podcast a couple of weeks ago. We're in a studio, there's decor, there's like a guy there doing thing, there's different shots. Apparently I was much more tan in that studio than I am here. And then we come to mine and it's like, hey, we're on Zoom because
Yeah,
no
but
one's hired.
didn't you get Tom Girardi on your podcast? Like, how did you? That's cool. You swung, and the timing couldn't have been more brilliant. Like, you got him before he was a criminal, and then boom, right? And then you had him, so he was already famous, and then he became the most famous attorney in California overnight, seemingly weeks after you did his podcast with him.
Yeah, they who was it? It was CNBC had an episode of American Greed. They had me on it actually. And they chopped up my original podcast with him to make me look a little sillier than I actually was. I found that amusing. But yeah, Tom Girardi was on my podcast. It's weird. I wonder if he even remembers who I am. I mean, I'm assuming so because that podcast became evidence, but wild.
So wild. Also, getting on American Greed, good for you. It's so interesting to hear you that they chopped up your podcast to make you look sillier, but you're so mature about that to realize like American Greed, I'll take it. I don't care how they make me look. Like that's such a big platform to be part of.
Yeah, they made it so that after he said something, I laughed, but they made me laugh quicker right after he said it, and they made my laugh a little slower, so it was longer, and I look more like I'm being suckered.
I see. They wanted to paint a certain narrative, even though you're just having him on a podcast.
Yeah. I was just happy just to be, like you said, on American Greed. That was pretty cool. It's an interesting thing. You said earlier that being a litigator makes people somewhat extroverted. Well, here's two litigators who have podcasts. How extroverted are we?
Yeah, there you go. I'm very grateful for that. The fact that I learned that about myself, that I get energy by talking to people, and in any shape or form. This is really great. I think I'm really grateful that you also showed me your hellish den, I think, as you described it. Like, I don't know if I'm even allowed to talk about it. To be honest, I wouldn't even be able to tell people where it is because I don't even remember. It was in this like discreet, hidden in like this residential area. Daniel invites me to this like, man, there's this like dwarf guy that was really cool, and just like he's the guy checking me in, and he knew you by first name basis. He's like, oh yeah, Daniel's not here yet. And he could tell that I was even your guest. Maybe he saw my eyes. I was like a little bit lost, like what the hell is this place? It was so cool. It was like this quasi hotel, quasi WeWork, stunning, just like dripping in intentionality in the design, like the mahogany woods, the different levels. And we get into this like room that's just, it's not describable, like the Persian rugs and the chandeliers and the dark elements, the paint. These people are just doing spoken word poetry. And like you're in there with them, and it's like all these like artistic souls, and you're just loving it. And you've been doing that for like 6 years or something, you said.
Yeah, I've been playing piano since I was 8, so it's always nice to I would say, taking the conversation back to trial, I would say insofar as whatever ability I have to speak off the cuff, I give a lot of that credit to playing music. I think there's a big connection between writing a song, which is giving a roller coaster of emotions, or telling a story, which is giving a roller coaster of emotions. One uses notes, one uses words, but they're both the same to me.
That's really beautiful. That's really poetic. I like that. The element of like, you think there's some jazz to litigation. That's kind of, it's nice. It's a nice thing to say.
Yeah, you're the easiest person to interview. It's because you're an interviewer yourself. So I don't even have to come up with the questions. We can just have a conversation.
Yeah. As long as I don't steer it too much to your personal life, I can tell you wanted to loop it back to trial. You're like, let's not talk about this trapeze artist, what the women are doing in the spoken poetry room. And no, I'm kidding. There's something really nice that you're a very multidimensional person. You have the bar association, you have this like artistic thing that people really should check out. It was an incredible experience. I don't know to the extent you're willing to open that up to people. But it was so interesting. And then just the fact that you keep creating all these meetings and like the podcasting, like you really give more than you expect. And I'm really grateful. It's a very nice thing. You give a good name to the practice of law, and that's something we need.
Thank you. That's very kind of you to say. And thank you not just for coming here today, which I appreciate. I really wanted to ask you those questions once you told me all those trials. I was like, whoa, okay, I got a lot of questions because I'm curious. But I also appreciate you having me on your podcast, and I appreciate the professionalism with which you go about it. I think anyone who's watching this podcast today can tell, oh, Jason knows how to talk. That's obvious. He doesn't even need Daniel here. No, he doesn't. He does this on his own without me, and with a much better production than mine. So it's been a pleasure. The hour went by real quick. I appreciate you taking the time. Thank you for coming on. Let us know a little bit about where we could find your podcast before we let you go.
Totally. I'm on YouTube, Jason Ingber podcast. Some of my friends call me Yitzy. If you Google Yitzy, you'll find some stuff too. I'm on Spotify and Apple. Definitely check out the Daniel episode. Really, really exceptional work, Daniel. Thank you. Thank you for everything.
Awesome. Jason, thank you so much for joining us today.
Thank you so much. Be well.